Good evening. My name is Corinne Mori, and I am your host for tonight's panel discussion. Tonight, we confront a critical issue in British Columbia. There is recent legislation that has decimated our democratic processes, transferring significant political power from the people to unelected government officials and bureaucratic regulations. Over the past few years, BC has seen the swift passage of several laws that were initially flagged as harmful, but now are recognized as being far more destructive than we anticipated. Our discussion tonight centers on the Legal Professions Act, examining its devastating impact on our judicial system and the ripple effects threatening the rights and freedoms of every citizen. Joining us tonight are three lawyers, Paul Jaffe, Gail Davidson, and Lisa Miron, who have tirelessly worked to scrutinize these laws and expose the undermining of our legal system. We aim to clarify the profound consequences of this terminal threat to our legal framework and the urgent need to correct it if we are going to sustain the protection of our individual rights and freedoms. Our first guest tonight is Paul Jaffe, a prominent Vancouver lawyer with decades of experience in criminal defense, family law, and civil litigation. Known for his deep expertise in navigating complex legal challenges, Paul has emerged as a fierce advocate for justice. In recent years, he boldly challenged the BC Provincial Health Officer Bonnie Henry in court over discrimination and the abuse of process. Leading high-profile cases, he's tirelessly defended individuals who were facing government overreach, steadfastly protecting their constitutional rights and freedoms in the face of growing legislative threats. Paul, can you tell that I'm a fan? Could you bring Paul on right now? Paul, you're a practicing lawyer in Vancouver. Could you provide us just a brief description on how the legal system actually works? The level of courts, kinds of legal action, just give us an understanding of the framework of our judicial system. Oh, one second.
Corinne,
Paul, we can't hear you. Oh, there you go.
How about now? Are we okay? All right.
You're good.
Well, I was going to say thanks for inviting me on tonight, and I'm very pleased that you're still a fan of mine, even though I, notwithstanding my best efforts, failed to sufficiently punish the Nurses College on your behalf when they acted with such irresponsible abuse of your rights as a nurse. But in any event, we might go into that history later when we talk about some of the problems that we're sort of noticing in our legal profession and our healthcare profession, and some of the other areas we'll be talking about. In any event, you've asked me how the law works. I'm more of an expert over the last few years in identifying ways in which the law isn't working. Basically, Corinne, as you know, the sources, the traditional constitutional sources of lawmaking authority in this country are the federal government and the provincial government. They pass what are called acts. And an act starts with a bill that's tabled in a legislature, that's scrutinized by the public, that's voted on a number of times, and that's eventually passed with or without amendments, proclaimed into force. So an act is a codified law that the courts will enforce. So examples of provincial statutes, which are all acts, would be the Motor Vehicle Act, the Land Title Act, the School Act. Examples of federal legislation be the Income Tax Act, the Banking Act, the Criminal Code. So these are all acts. And historically, the whole theory of parliamentary democracy is that back in the 1200s in England, there was this great thing called the Magna Carta, which was a time in the history of the English legal system in which the rule of the king was challenged. And the lawmaking authority of Parliament became paramount. And so we have inherited 800 or 900 years of that principle that our society is governed by the rule of law, and the rule of law is one which has its roots in the democratic participation of people chosen by the electorate to enact these laws. Um, that's the theory behind parliamentary democracy. What's happened in the last few years is that there's been this growth of what we call the administrative state. And I suppose the best example and most recent one, and perhaps most clear in the minds of most people, might be what has taken place over the last 5 years in relation to many of the pandemic related issues that came before the courts. Governments have found a way to avoid effective legal challenge to acts by simply exercising authority through delegated administrative officials. So you have a growth of administrative power exercised in ways which cannot be effectively challenged, and it's obviously more complicated than I can go into right now. But essentially, the effect of that is that it permits governments to advance ideological objectives in ways that can be immunized from effective legal challenge. And one of the ways that happens is it bypasses what was supposed to be the guarantees provided by our Charter of Rights, which is a part of the Canadian Constitution that is supposed to be paramount, and the exercise of government powers in ways which infringes these rights is supposed to be struck down by the courts. None of that has happened in the last few years because of the growth of the administrative state, administrative law principles, and what I see as an increasingly politicized and ideologically driven judiciary. So the theory of parliamentary democracy has, in my view, been significantly compromised over the last 4 or 5 years in ways that I can go into perhaps further as we go through the evening. But that's yeah.
So if I let's see if I can clarify, repeat this back to you. So we originally have a legal system that was, well, that's going to be my next question. What is the purpose of the law and the legal system in our society? Because if we don't have that established as to what the original purpose of the structure is to enforce in our society, then how do we know if we've strayed from it? What I'm hearing from you is that the proper format is that we as citizens of our country elect representatives for us that go to government and create laws that we are participating in and agreeing to. But instead, what is happening is these government structures are actually giving unlimited power to basically appointees or employees of the government who have unprecedented power to enforce things without the involvement of the public. Is that a correct interpretation?
Yeah, that's pretty good. That's what's happening. Is there's been a movement away from the legislatures into various bureaucracies where delegated authorities are given discretion to exercise their decision-making powers. Best example, I suppose, that I can think of right now are the actions of Bonnie Henry, for instance, during the pandemic, where she could shut down. I mean, as you pointed out in your introduction, with the Justice Center for Constitutional Freedoms out in Calgary, were on behalf of a number of churches in BC, challenging what we contended to be a very arbitrary and discriminatory restriction imposed just on churches. All the secular venues were open: pubs, schools, shopping malls, restaurants, gyms, support groups, the courts, businesses were all open, subject to certain protocols: social distancing, contact tracing, these kinds of things. But quote, worship services, in other words, if you gathered for the purpose of worshiping, notwithstanding that there's not an epidemiologist in the world who would say that the subject of discussion presents a health risk, and notwithstanding the fact that churches of all the venues were the most capable of maintaining those public health related protocols, Bonnie Henry used her public health purposes to prohibit any worship gatherings of any kind, whether inside or outside, regardless of the numbers and regardless of the steps being taken. While at the same time you could go to the pub and watch the Canucks lose another game, you could not worship. So clearly that was a great example of a public health power being used for a political or ideological purpose. Now, you would think in a country with a constitution that supposedly guarantees freedom of religion, peaceful assembly, thought, opinion, belief, conscience, and these fundamental freedoms, it would be a no-brainer to come into court and set aside that restriction on the grounds of it being arbitrary, politically driven, unrelated to the purpose of the Public Health Act. But what the courts did both in BC and across the country, they applied these administrative law principles to immunize public health officials and to prevent an effective legal challenge. Only the evidence considered by Bonnie Henry here and her counterparts across the country, only what's called a record of proceeding, was admissible evidence in those challenges to these kinds of measures that were imposed. The vaccine mandates are further examples. We had we had experts who were eminently qualified. Not that you need expertise to point out how irrational and discriminatory the particular restriction at issue was. I mean, that's a matter of common sense, but common sense doesn't play a great role in our legal system. So we had experts lined up, and the administrative law principles that prevented any effective legal challenge was that the decision maker whose authority is being questioned has a monopoly on the evidence to put before the court. And the second thing is the courts accept the government narrative without any evidence. So they take what's called judicial notice of information or misinformation promulgated by government spin machines, such as the danger of the pandemic and the safety and efficacy of the vaccines, all without evidence. So the starting point is those challenging these restrictions had a tremendous uphill climb to fight their way through the narrative that the courts accepted, but we were not allowed to tender expert evidence to show how irrational and unscientific these restrictions were. So it's a combination of two things which affected challenges across the country. Now, what I fear is that governments have learned that their success throughout the pandemic in resisting these kinds of challenges, in a sense, is a great inducement for governments to henceforth exercise power through delegated authorities who cannot be challenged for the same reasons that the pandemic-related litigation failed. So we have moved lawmaking authority from the legislatures where it could be effectively challenged, because an infringement of an act, the government have to come to court with cogent and persuasive evidence and demonstrate that that's a reasonable limit prescribed by law, demonstrably justified in a free democratic society. It's a real onerous test on governments when they violate your rights in an act. But when governments use delegated authorities to violate your rights, the government has no such heavy burden to justify an infringement, and the administrative law principles prevent an effective challenge. So yes, there's lawmaking authority moving from the legislatures into the bureaucracy in ways that can't be challenged. And I find that, especially in the context of ideologically driven governments, as we've seen in Ottawa recently and as we see out here in BC, I see that as a very significant concern.
Could you give us a brief description of the changes that you have seen in the actual function of our legal system, say from 10 years ago till now?
When I first started in the practice of law, just this side of the last ice age, I was working in the criminal courts. I was a prosecutor for a number of years and defense counsel for a number of years at a time when the Charter of Rights was taken very seriously. And that onerous burden on the Crown to justify infringement was alive and was the defining feature of our constitutional litigation back in the first 20 years or so after the Charter came in. Towards the late 90s, the evolution of administrative principles evolved, and we have seen, as you know, in Canada, judges are appointed by Superior Court judges are appointed in Ottawa, essentially by the Prime Minister and Cabinet. The Attorney General or Solicitor General is the official signs off. Provincially, it's the Solicitor General or the Attorney General, but it's all done through Cabinet. So you have a necessarily political system of sorts. This is inherent to any institution in which people are exercising their powers. This has always been the case. But what's been most problematic in Canada is there are no checks and balances in Canada. There's no separation between the executive, the legislative, and the judicial branches of government. They're all consolidated really within the Premier's office in Victoria or the Prime Minister's office in Ottawa. So we don't have those checks and balances that protect people. And we also in Canada have this thing called Section 1 of the Charter. We don't have anything analogous in the States. When a right is guaranteed in the States, you have a more independent judiciary ascertaining whether or not government has the right to certain measures. In Canada, judges, who, remember, are all appointed by governments whose actions are at issue. Judges decide whether the particular infringement that you can prove is a reasonable limit or not. And whether something is a reasonable limit is a very subjective exercise, depending on their own perspectives. So we've taken the inherent, I suppose, weakness of any judicial system and empowered that weakness by injecting this massive, powerful requirement for judges to exercise their subjective opinion as to whether or not a particular government measure is a reasonable limit on your freedoms. Critics of the Charter back in the early 80s foresaw the inevitable politicization of a court system, and they were concerned about it. And I think in the last 40 years, we've seen very good reasons why those concerns were well-founded. And I think in the last 5 years, with like I was referring to the pandemic-related litigation, that's really brought home to many of us the fact that those very early concerns about the Charter expressed in the early 80s have been proven. Were very well-founded. I can't really remember what your question was, Corinne, but I think I probably covered it.
Well, it seems that we have an issue where our judges are appointed by the government, and to get the appointment, you need to be sympathetic and cooperative with that particular party that's in power to get the job. And then to retain the job, you need to also be cooperative and aligned with the party that has put you into play. So I can see a conflict of interest here. I'm going to introduce Gail Davidson right now.
Sure.
Gail Davidson is a legal activist and educator who for the past 25 years has championed international human rights and humanitarian law. As part of her work, Gail has delivered legal education presentations all over the world, as well as at the UN Human Rights Council in Geneva. John, if we're able to bring Gail on, that would be great. Recently, Gail has also focused on the failure of Canadian laws to uphold international human rights standards, democratic governance, and rule of law principles, particularly in the context of BC's legislative challenges. I'm curious, Gail, many of us struggle to understand just even federal and provincial laws. Can you maybe explain to us what is the role that international human rights laws should have on what is happening in our country?
Okay, I will try and do that in a shorthand way. As probably all the listeners know, Canada is a member of the United Nations and of the Organization of American States, and has signed many human rights treaties, principally United Nations treaties. And those treaties that have been signed and ratified by Canada impose legal obligations on Canada, all the provinces and territorial governments, so on British Columbia. And I'll stick to I'll just mention 3 legal obligations imposed by international law on BC that are relevant to the Legal Professions Act. Number 1, they impose an obligation to ensure democratically elected governance of the legal profession that is capable and does operate independently from government and is mandated to uphold the rights and freedoms of all and capable of challenging unlawful government actions. Number 2, ensure that every adult person has the right and opportunity to take part in the conduct of public affairs through meaningful consultations about changes to laws. Number 3, the obligation to protect the rights and freedoms of all, including rights to fair trial and to be represented by a lawyer. And those are part of international law obligations. As your listeners know, the Canadian Charter of Rights and Freedoms starts out stating the supremacy of the rule of law, which is an international law principle, as Paul has aptly described it. The one of the obligations flowing from the rule of law is to have an established system of democratic lawmaking that is known and followed. And the established processes require a number of things. I'll just name them off in lawmaking: transparency, timely notice of the proposed changes to the public and to, in this case, members of the Legislative Assembly, access to information both for the public and for elected representatives that's needed to assess and debate the necessity, legitimacy of the proposed changes, meaningful consultation, particularly with the parties likely to be most affected, a full review, informed debate, and amendments by elected representative, consensus, generally of the public and formally by a vote of elected representatives, and finally, the law, if it is passed by the parliament or the Legislative Assembly, has to be declared in force and then published in a form that is accessible to the public. So in British Columbia, the publishing outfit is called, unfortunately, the King's Printer. So those are the 3 things that basically laws in a democratic society have to comply with. They have to comply with rule of law principles, democratic requirements of lawmaking, and with the protection of rights. And the development and enactment of the Legal Professions Act did not comply with the rule of law, democratic lawmaking processes, or the duty to protect rights. So that is the problem.
Okay, so you, in the last few years, have done a deep dive into specifically 2 different acts that were passed in the BC legislature, the Healthcare Professions and Occupations Act, and now this Legal Professions Act. I'm going to just give you full time right now to go through the process of, as you were going through the legislation that is now currently in effect, what have you noticed? What's your concerns? Do you see a common theme or goal that is being constructed through these acts? Just please take your time and lay it out for us as simply as possible.
Okay, first of all, I want to say I don't like people to think I've done a deep dive. That sounds like I've done my PhD in the Legal Professions Act, and I haven't. I have tried to carefully look at the statute. It's fairly long. It's 317 sections, and I think that's 136 pages. It's a little shorter than the Health Professions and Occupations Act. I want to also clarify that I'm not a lawyer. I'm a retired lawyer, and that's a very different creature, both practically and legally. So to talk about the problem with the Legal Professions Act, first of all, I wanted to I'd like to say something about the primary function of the legal profession in a democracy is to act as a safeguard against violation of rights, overreach, and abuse of power by state authorities, and the imposition of tyrannical measures. Now, to fulfill this function, lawyers must be independent of government control and free to act vigorously against the state without interference or direction, particularly in case of criminal charges, determination of rights and obligations, the legality of laws and the legality of state actions. The Legal Professions Act, in my view, and when I'm referring to the Legal Professions Act, I'm referring to the Legal Professions Act of 2024. There is still partly in force the Legal Professions Act of 1998. I'm not referring to that. The Legal Professions Act that was passed by the Legislative Assembly on May the 15th of 2004 potentially impairs or destroys the independence of lawyers and prevents the legal profession from fulfilling its essential democratic function. This, in turn, robs clients, robs people of their right to be represented by an independent lawyer, and, in my opinion, robs their potentially restricts or impairs their right to their fair trial rights. Now, the opposition to the Legal Professions Act was and is huge. The groups that are opposing it include the Law Society of British Columbia, which is the current governing body of the 14,000 lawyers in British Columbia, the Canadian Federation of Law Societies, the Trial Lawyers Association of BC, the Federation of Asian Canadian Lawyers, the Alberta Civil Trial Lawyers Association, the Saskatchewan Trial Lawyers Association, many local bar associations, including the Abbotsford, Surrey, and Vancouver Bar Associations. All of these oppositions, learned oppositions, most of them were ignored by the BC government. And then the bill, as I say, was passed on May 15th, but also passed in non-compliance or violation with democratic lawmaking processes. A vote was forced by the BC government when only 9% of the provisions of the Legal Professions Act had been reviewed by members of the Legislative Assembly. And now the BC government, the opposition has continued. The Law Society of British Columbia and the Trial Lawyers Association of BC both started separate legal actions asking the BC Supreme Court to challenging the constitutionality of the Legal Professions Act. Both of them took an application immediately after it was passed to the BC Supreme Court, asking the court to prevent the transition provisions of the Act from being carried out and the Act from coming into force until the constitutional challenge had been decided. The court in July 17th of 2004 rejected both of those applications and went on with the transition process. Now, the Act, as I say, the Legal Professions Act, only the transition sections have been declared in force, and what is happening under the transition provisions is there's statutory provisions where there's many people being appointed, and many of those appointees are empowered to make laws, rules, codes of conduct over virtually every aspect of the delivery of and receipt of legal services in British Columbia. And the Law Society, the governing body of lawyers.
May I just jump in here? So
Sure.
to make this easy for the public to understand, what you have concern about is the legal system and our law structures and our lawyers are responsible to ensure accountability both for citizens of our province, but also it holds the government to account. And in order for it to exhibit that balance of justice, it needs to remain independent. The people who are functioning as lawyers need to be free from any kind of coercion or influence from the government. And yet, what has happened now is what used to be a self-regulated society, the legal professions, has now had that structure removed from them. They are no longer allowed to be autonomous in how they practice. And they have now had government appointees that are given authority to dictate to the profession how it has to operate. Would that be a concise
That's
and
a
accurate statement?
Hang
that's
on,
a fair.
hang on 1 second. This is John on the background here. Just to point out, Gail, you've mentioned 2004 a few times. I think you meant 2024.
I did.
Okay. Carry on. Sorry for the interruption.
Okay. Thank you, Corinne. I just want to mention, yes, that's a pretty fair assessment. I just want to finish saying that with the transition provisions, the people that are making these rules and bylaws and regulations that are going to be binding, most of them aren't even known to us. They certainly aren't elected and they aren't accountable. And whether or not they're competent would be a matter of opinion. The Law Society of British Columbia, lawyers' elected governing body, is compelled by the Legal Professions Act to cooperate with transition. And the Law Society of British Columbia is also compelled to pay some of the costs of transition. And when the transition process is completed, which is expected to occur sometime in the summer of 2026 or the early part of 2027. So I hope I said 2026. Yeah, that's what I meant. And at that time, the assets of the Law Society will be turned over, seized by the governing body, which will be basically a government body. So right now, the lawyers in British Columbia are governed by 25 benchers who are elected and by the lawyers. And lawyers have various mechanisms by which they can disapprove of decisions made by the benchers and turn those decisions around. So that democratic governance that's currently in place will be abolished and replaced by a 17-member board composed of a majority of political appointees who will not be independent from government. There will be only 5 elected lawyers on the governing board. And yes, I mean, I could go on and tell you other things if you want to, or did you want to
So
interrupt?
this highlights, there was a comment I believe Paul made earlier about the level of competency that is actually driving the decisions and the structure and formulation of how our society is going to be governed. And then if you are ensuring that those who are overseeing the legal profession actually have very little education, experience, and knowledge about that environment and profession and nuances, it would suggest that it will drive the function of the legal profession down. Again, decimate the very structure of the democratic process. So you've mentioned that the lawyers themselves are trying to create some kind of resistance against this. What's your forecast? Do you think that they will be successful in driving back the government overreach?
I don't want to posit any opinion on that. I hope that they will be successful, obviously, and I have no idea if they will be successful. But the Legal Professions Act, as you have already said, is unfortunately not a one-off. It's part of a pattern of lawmaking in British Columbia and Canada and globally that is using democratic processes, parliamentary processes, to replace the law that is intended to maintain democracy, rights, and the rule of law with laws that are effective tools to establish and maintain repressive control and to prevent access to any kind of remedies for those measures. So that's one of the big concerns, because obviously, I mean, I have no idea what the intention is. I can only make assumptions about what the intention might be, but it seems uh, that people in power have known for, as Paul was mentioning, for centuries, that one of the things to do in order to have the power, have the way open to establish repressive control is, as said by Dick the Butcher in Shakespeare's Henry VI, was published in 1594. What we do is first we kill all the lawyers. First, what we do is kill all the lawyers, meaning possibly figuratively speaking, to get rid of the lawyers. And so muzzling the lawyers with the Legal Professions Act, or having the potential to muzzle them, seems very much of a way to gain undemocratic control over the legal profession and therefore reduce the access of other citizens to the legal representation that is often or always necessary in order to properly redress government overreach or unconstitutional laws or abusive measures that are abusive of power.
Okay. Paul, do you want to jump in? Do you have any concerns about the political intent of the recent legislation coming through the province of BC?
Yes, of course. As Gail says, the changes to the Legal Professions Act are similar to what's happening in other areas, like the Health Professions Act, and even the Emergency Act, which we can talk about. But in any event, what they all represent is an expansion of government powers. With respect to the Legal Professions Act, disenfranchising the membership of the democratic right to elect their own governance, which establishes the necessary independence. Because we talked initially, when I first started speaking, what an act is, which is it's a law passed by the legislature, and then the administrative powers are all exercised by delegated authorities under these acts. But a vast amount of the litigation going on in the courts involves government actions. So there has to be an independent bar to properly advance those hundreds of cases that at any one time are in the courts at all different levels and all different areas where government actions are at issue. So when the government directly takes over the governance of the legal profession, lawyers potentially lose the right to advance these challenges as they would wish to do, because they are now being governed by political appointments who may very well agree with the actions of governments that are at issue and may very well take steps against lawyers in various ways, sometimes quite overt and sometimes less direct, but the implications to lawyers who, in the minds of political appointments, may be on the wrong side of an issue, that's a scary thing. So the law societies, professional governance of the legal profession, and quite frankly of other professions as well, guarantees the independence of those professions, which becomes
Yeah,
increasingly important when government actions themselves are at issue.
yeah.
So I think I'm echoing some of what Gail has said, but yes, those are
Mhm.
my concerns.
And if I can say, the lawmaking by appointees and bureaucrats that Paul is referring to, the Legal Professions Act, and this is also exactly the same with the Health Professions and Occupations Act, neither of these bills imposes any requirement whatsoever that the laws adopted or created by appointees comply with Canadian law or international law, or even serve an accepted, democratically accepted public purpose. Now, both the Health Professions and Occupations Act and the Legal Professions Act give political appointees, along with cabinet and a couple of ministers, but cabinet without the oversight of the legislature, the power to adopt as binding in British Columbia any regulation, code, standard, or rule enacted by, quote, another jurisdiction, including a foreign jurisdiction, or set by a provincial, national, or international organization or body that may make code, standards, or rules, close quote. That is what both statutes do. These provisions would enable adoption of laws made anywhere, China, Saudi Arabia, um, uh, rules made by the WHO or the WHF. Uh, Obviously, that's a terrible thing. Now, both of those provisions in both the health professions and occupations and the legal professions, those weren't actually approved by the Legislative Assembly in BC, because in both cases, voting was, closure was invoked and voting was forced before, the elected members had got to those provisions. And also in both cases, I think it's probably fair to conclude that the, um, NDP, the majority vote, was a whipped vote. It wasn't a free vote. The Legal Professions Act and the Health Professions and Occupation Acts also create criminal civil offenses that violate the principle of legality, predictability, and freedom from ex post facto laws. So, in other words, freedom from laws that apply retroactively, because the offenses are so broad and vaguely worded that you can't know in advance. You can only, you can't be objectively interpreted, and therefore you can't avoid the offense or the crime, and you can't defend it. And both of those statutes create those type of offenses. So those are just some of the things that are offensive about the Legal Professions Act. And when I say offensive, this is all potential, because neither the act, neither the Legal Professions Act or the Health Professions Occupations Act have been declared in force. So this is the potential they have to create a sort of chaos where rights can be summarily set aside, where democratic processes are not even considered, where compliance with existing law, existing international law obligations, or rule of law principles are not a necessary component of the laws made by the appointed people under these two statutes.
Okay, so I have a question, and it's going to come from a very simple level, because I'm trying to assimilate all that you're saying, but what I'm hearing is the legal system is deteriorating. There is a reduction of protection for individual rights and freedoms, as the government now increases administrative and bureaucracy levels where we have employees and appointees who have the right to implement more regulations on us and more laws, but the legal system itself is blocking the ability for relevant evidence to be introduced to argue the correction. And so I'm getting the sense that we have to have righteous people on the inside who can actually rectify the legal system, but it's created in such a way that we're almost past the point of that being able to happen. So please correct me.
Okay, so I'm not talking about the deterioration of the legal system. Paul has talked about the shortfallings of the legal system and its inability to provide meaningful judicial review. What I'm saying is that these two statutes entrench undemocratic lawmaking that cannot be, and they entrench immunity from any kind of review of the undemocratic lawmaking. The laws that are to be made under these statutes that are authorized to be made need not comply, as I said, with existing law or existing international law obligations. They don't even need to have to be necessary, reasonable, justifiable. So if you recall the words of Justice Mosley in the challenge when he was determining the legitimacy, the lawfulness of the invocation of emergency measures by the federal government, he concluded that the imposition of emergency measures was unreasonable, unjustified, and unlawful. Now, none of these two acts I'm talking about, the Health Professions and Occupations Act and the Legal Professions Act, there's never been a public discussion about the necessity for these huge changes. Basically, the main thing that the government has said is they've said, oh, well, there's a need to modernize. And both the statutes I'm talking about are based on the report of Harry Caton. And he's not a legal specialist. He's not a health specialist. He's not trained in either of those disciplines. But Mr. Caton says in his report, he charged $500,000 for each of his reports, very short. And in both of them, but particularly in the report regarding the governance of the legal profession, he said that elected governance was no good because it was too cumbersome. It took too long to make decisions, and it risked giving the appearance that the governance of lawyers would be carried out for the benefit of lawyers rather from the benefit of the public. And so to put the lie to that, we look at the Legal Professions Act of 1998 has a statutory purpose, and that statutory purpose is to protect the rights and freedoms of all and to ensure the integrity and competence of the legal profession. There is no statutory purpose in the Legal Professions Act of 2024. Instead, it has two goals. One goal is to increase access to legal services in British Columbia, and the other goal is to reduce discrimination. Now, the Act, as it was approved and passed in May, doesn't have anything whatsoever to do with either of those issues. The only approval, the only increase in access to legal services that might be created is the government has um, appointed uh, uh, a woman and Lisa Trabucco and a group of people to create laws and rules and regulations about paralegals. So the assumption is the new provisions will say that instead of having access to a lawyer in many kinds of disputes, one will now have access to a paralegal, particularly maybe in
Oh,
cases that are covered by legal aid. I'm just supposing there. But
mhm.
other than that, there's nothing that would increase legal services. So the Legal
Okay.
Professions Act doesn't actually have a statutory purpose.
Okay. I understand that you have to hop off the call, and so thank you for joining us tonight. John, our producer, I'd like you to get Lisa ready, who will be on after. But I have one more question for Paul before we bring Lisa on.
Actually, I have a question. It's I have a question from one of our viewers, from Lisa. She and Paul, you can address this, I guess. How much authority does the Crown really have on Canadian laws?
How much authority does the Crown have?
Yes,
So I don't know what if you're referring to how much authority does King Charles have?
I
Uh,
think that
well,
I'm not sure what she means, but
okay,
that's
I'll just quickly answer this and then I'll go. But unfortunately, with Mr. Carney as Prime Minister of Canada, it seems that King Charles might have be able to exercise some of that authority that exists in the British North America Act, more recently called the Constitution. Um, Mr. Carney referred to Canada as having a constitution, a constitutional monarchy. But so I don't know who you're referring to as the crown, because
That's okay. We'll move on to the question that I had for Paul, please. Um, Paul, we live in a society that we believe operates under a democratic system, which simply means that the public believes that we participate and agree to political decisions that impact our daily lives. Do you believe that democracy is something real and attainable? Do you believe that BC is actually operating as a democracy?
Our
Oh,
so-called
hold on one
democratic
sec. There we go. Okay.
institutions, our so-called
Sorry, your sound
democratic
was off. Go ahead.
institutions, the legislatures at both levels of government operate on the theory of representative democracy. Um, they are obviously um, deeply flawed. I mean, a recent example was the challenge to Justin Trudeau's prorogation of Parliament at a time where his leadership had come to an end and shut down Parliament for the purpose of enabling the Liberal Party to have a leadership change. It was challenged in the court, saying, you know, prorogation is an extreme measure intended for special circumstances that are quite unrelated to the political interests of a party that's undergoing a leadership change. The federal court upheld the validity of the prorogation, saying it was essentially the request made of the Governor General was permissible, and her authority to proclaim it was permissible. So really, it confirmed that on what might be fairly characterized as the whim of the Prime Minister could shut down Parliament. So it's hard to really pretend that we live in a parliamentary democracy where the representatives of the people are an effective voice in Ottawa or in Victoria. Getting back to a question earlier, but it kind of relates to this: is the Crown? What is the significance of the Crown? Well, all laws at both levels of government are proclaimed into force by royal assent. So all laws, even since the Magna Carta Magna Carta in the 1200s, all laws have always been of the crown. It's just that Parliament gets to decide what those laws are, and they become enforced by the crown. That's why in all the criminal courts it's Regina or Rex now versus Smith or Jones. It's the crown versus. So the crown's all laws are theoretically rules imposed by the crown that the courts will enforce, but those laws have to be passed in the legislatures. So the crown is symbolic. The crown is the rubber stamping of legislation passed in those legislative bodies. Getting back to the question of democracy, you can count on one hand the number of times in the last decade that backbench MPs have stood up against the party's position in either the House of Commons or here in Victoria. It is exceedingly rare that an elected member does anything but toe the line in both legislative levels. So one could argue just on the basis of that, it'd be difficult to characterize those institutions as democratic. Having said that, they're the best we've got. They have historically worked reasonably well. I think in the last 10 years or so, we've taken a big slide in many ways, which I'm sure we don't have time to go into. But I think the history of this country over the last 150 years has shown that as imperfect as our so-called democratic institutions are, we're certainly better than most of the world. Like I say, we've taken a really big slide in the last decade or so in ways which might be somewhat time-consuming. But anyway, that's my not particularly clear and somewhat rambling answer to your question, Corinne.
I appreciate the honesty. I would say that the public is feeling the shift of things that are going on, and we don't really understand, but we can feel it, and we know that things are very unstable. And really it is because of the efforts of those like you who are bringing us the details of what is really going on behind the scenes so that we can all understand and appreciate how quickly things are moving and the need to learn how to protect yourself in this environment. Our next guest is Lisa Miron, who is a lawyer of 26 years. She has a master's of law in conflicts of interest and an honors Bachelor of Science in environmental science with a minor in chemistry. Lisa has also recently published a book titled World on Mute: How Workplace Speech Committees Are Destroying Our Nations and Eliminating Our Civil Liberties. This is available on Amazon. Lisa's book highlights that censorship highlights the impact that censorship has had on professional bodies. So that would be your colleges of physicians, your law society, etc. And this censorship has had a considerable effect of undermining the democratic governance that is occurring in our country. Lisa identifies the constriction and restriction of free speech in the workplace as being one of the most impactful reasons for the current erosion of our constitutional rights and national governance. Lisa, please tell us your story. Oh, we're just going to get your sound on, Lisa.
Thank you for having me here and for inviting me. And I very much enjoyed listening to both lawyers that were commenting. And I had the opportunity to, I think, appear before Paul Jaffe as a commissioner of the NCI. I sued the government in the first SARS case. I represented the family of Nelia La Rosa. She was the first nurse who died of SARS. And I started paying attention to the pandemic with the eye of a lawyer who knows that government can get it wrong sometimes. And I've had other large file litigation, and I did some even class action work. I was in-house in the tech and auto sectors, and I have a family. I started writing what I was observing in a Substack, and my focus was always on the tension between globalism and nationalism. And I think it's the onset tension of our times that any of our culture wars or what have you can be rooted to that. And with that in mind, I started to see the speech committees that were being put together in cases like the Dr. Trozy case or the Jordan Peterson case for a Canadian context. I started seeing them as part of a global apparatus. And so, what I want people to envision is that every way to earn a living transnationally is and transoccupationally is being gathered. And it's being knitted together, and think of it as a huge quilt, and we're all being assembled into this governing regime. We traditionally think of professions like doctors or lawyers as areas that are governed professionals, but it's real estate agents, it's headhunters are now being gathered. It's it doesn't matter what way it is that you can earn a living, you're being regulated. And with that, and this is the world around, you're getting a speech committee. And when you get the speech committee, it doesn't matter that, notwithstanding that there's a ton of terrible speech, unruly speech, rude speech all over the internet, it is the same speech the world around that is being culled. And so I wrote the book probably 3 times as I assembled the ideas that were coming together. And what I want people to think of is, yes, today we're discussing 2 egregious bills in BC, 2 absolutely egregious, and I would call them the tip of the spear. But what we have generally as a trend is that speech committees are being applied. And what happens is that the speech you cannot have, it's not the topic. So you can, for instance, talk about the vaccine all day, but it's the side of the topic that you are allowed to get. Or you can talk about big disease, in any of its iteration, but it's the side of the topic that might get called. Climate has the same event, or immigration. And pro-nation state speech, speech that supports rights, property rights, is also speech that gets called. And so I ended up seeing the speech committees themselves as instruments of the globalist order. And my argument in my book and my thesis is that when you become regulated with a speech committee, because of the deference, which is the court's enforcing of these new norms, right, when they're being challenged under judicial review, because of that deference, you become a regulated subject, no longer a citizen, and you become a global citizen. You are part of this globalist order. And in so long as we continue to examine our world in relation to the tools that traditional legal architecture gives us, right? Our constitutional arguments, we go to the statute, we go to the common law, and we go to perhaps other jurisdictions. We might lean on that. We might lean on, some academia. My point is, if the courts are being attacked, and we'll go into the legal profession right now, by a rogue body, right? So this rogue body has the power to curate the lawyers that are able to practice based on globalist speech exactitudes that enforce the globalist order. Then you can, it was my theory, and then I ended up finding the cases in my book, you can, in fact, eliminate the lawyers that would be present to challenge government overreach in the various legislative, executive / administrative branches, and other globalist type agendas. That might be the big pharma agenda, challenging vaccine injuries, etc. If you can cull the lawyers that will bring those cases, then everything looks the same. You say hi to your neighbors, you go outside, you see the courts are still there, everybody's employed. However, that balance of power that was promised in the Constitution is gone. It's gone. It's gone permanently. And the reason why it is gone, and the reason why I wrote this book, is to give people these new arguments that I see in all these cases. The reason why it's gone is because unless a lawyer is there to file a case, the courts don't render a judgment. And so that perfection of the Constitution, of the balance of powers, has been neutered by a rogue administrative body. But it's not just any administrative body. We're not just talking about the rise of any administrative state. I say also that this system is social credit. It is the system of the globalists. So social credit would be the idea of where, you're in China, and if you agree, with certain principles, or you behave a certain way, you get a credit system, and based on that, you have privileges. You might be able to send your kid to a better school. I review their social credit. But we are setting up speech committees that enforce social credit. And I say, too, that in my book, that if you have to agree with your party, I'm saying party, in a broader sense, to earn a living, if you have to agree with your party to earn a living, that's communism. So again, the courts are the only upholders of the rule of law. They are. And we are officers of the courts, and the judges are officers of the courts. And if they do not have mechanisms to outlaw our society turning into communism, they failed. They have failed, and we as lawyers have failed, right? So we have a system where Dr. Trozy has to agree with a professional body, which is a rogue administrative state. And I traced, their globalist intrusion all across the world, into Pakistan, into South Africa, right, into Brazil, into the EU, it's the same order, the same speech committee, and the exact same speech you cannot have. It's the same mechanisms. The worst iteration of it, however, is in BC. So if the courts can't recognize that what is rolling out is communism, and they can't outlaw our society from turning into communism, they are failing us. And so I'm trying to expand, how we see these speech committees, right? I don't want the pigeonhole of of our current analysis, because we've never crossed this Rubicon before. I say this is the courts of the globalists, right? I think if we don't take these speech committees down and take them down as a globalist system, right? We're wounding them in the Trozy case, or the Hoff case, or the Sue Gray case in New Zealand, or Bet in Germany. We're wounding them, but we are still seeing them as ad hoc cases where, in effect, this is one globalist beast system, and it has designs. It has a directionality. This is not a failing. It can't arise so simultaneously all at once and not be connected. So that's why I wrote the book. And the book goes from a narration. You meet in a titan who is taking on this system. And it goes into my theories then on how to explain what it is that we're seeing. how to contemplate it, how to beat it. And governments in all of history have either operated on dialogue or force and violence. And it's quite axiomatic, it's obvious to me that as we cull our speech, we cull our ability to dissent with government. And so as the economy gets worse, those people who are able to dissent become smaller and smaller. I would say about 20%. I say a person who's regulated right now is in bondage. They're in bondage. They're a global citizen, and I'd say about 20% of them resent it. They're silent. They have a mortgage to pay or rent. They have children to feed, or they have obligations, and they're trying to get by. And so they're towing the line on the trans agenda or the woke agenda, and they're towing the line on whatever medical fascism is arising, and they're towing the line. But they're in bondage. And a lot of people who are speaking right now are either on the other side because they've been targeted, right? They're a titan, or they're an independent. They're independently wealthy. They're a farmer, and they have independent businesses. And so at the same time that we're placing, this great coincidence, we're placing everybody in a regulated profession and we're giving them the same speech committees. At the same time we're doing that, we're also having a very large economic attack on the small business. That was the COVID agenda, right? We're having a very large attack on farmers, we're making it harder and harder to earn. We're having egregious taxes. So the economic system is folding in on this globalist system. I meticulously tie it down to research and show how serious the censorship regime is. And then I saw that the speech you can't have hides a pillar of the globalist state. And I put in my book what I perceive as the pillars of the globalist state. I do have an environmental science degree with a minor in chemistry. And at one point, I would have told you, I believe, the carbon dioxide issue. I don't. However, that is also an area you cannot dissent on. My next book will deal with the municipal deep state that is also globalist linked. And I do a lot of podcasts on the smart city, the C40 city, the global covenant of mayors, and that. So that'll be my next area. But this area, it's a 500-page book. It goes from medical to legal, political, to woke ideology, and then to the emergency powers. And speech is now the new emergency. The powers that you would get for radiation or some kind of disaster or hurricane or what have you, the kind of powers that you get, they want for speech. And that's really, in Bill 36 in BC, that's really, really obvious. In the system, I found that the snitches who are ratting out the individuals are often within the system itself. So it's sort of circular. You can use the example of Bonnie Henry and Dr. Hoff. And, Dr. Hoff in an email, and this is in the book, and many in BC and yourselves are aware, but he wrote Bonnie Henry in or around April of 2021, indicated that there was a horrific amount of vaccine injuries in his patients, and he was sad to let her know. And within 24 hours, she had instructed her staff to report him to his, his speech committee, his governing body. And so you can see that the governing body was supposed to be weaponized. It is now a weapon utilized to buttress the silence. In most of these cases, the media was very unfavorable about those who were going through the system. It was either biased or they omitted factors, or in some cases they even misdescribed what the allegations were. Dr. Chetty in South Africa, he was even described as being found guilty before that had occurred. Um, and I always thought to myself, well, if they go after the lawyers, if they're able to cull the lawyers, then we're really hooped. It's the 12th or it's the 11th hour. And in some ways, though, too, if we do succeed in waking up the lawyers, and we succeed in impressing upon them that they're not accidental lawyers, they're not there for any other purpose, but that they are officers of the court. And with that comes an obligation, a phenomenal obligation. The officers of the court are supposed to stand for the principles that this Constitution and the balance of power stands for. And we are supposed to, as officers of the court, not stand for our country to turn into communism and not have be able to articulate it because it hasn't been articulated before. So I am hoping that the horrific things described, right? The idea that now China, South Korea, rogue powers can actually even make law through the Professions Act and the Legal Professions Act, and indeed in the Health Professions Act. I hope that wakes the lawyers up. I hope that they understand what it is their obligation is as officers of the court. It's very, very important. And I hope that it does the same with judges. And if we haven't had luck before, it's because we perhaps haven't really understood what hour we're at. And I cried when I read Bill 36. I did. I wept. I didn't cry a little. I wept. I wept, and I saw that we are setting up Stasi units. And we're giving them egregious powers on demand. We're giving them powers that they can make themselves. And if we haven't given them enough, we get to give them more. And it's a black box that accords with anything that any globalist rights anywhere, right? This whole idea that laws made and passed by the UN or what have you can be brought in. And we have the remedy, those powers, these Stasi units are set up top down. And the top of that is Bonnie Henry, right? Once again, it's Bonnie Henry. And to lawyers in Canada who think, well, this is BC, that act has long arm jurisdiction. As I read it, it indicates that any profession is bound. Anyone who communicates with a profession, a regulated profession, so A&T. Anyone who is an occupation, are we occupied right now? What's an occupation, right? And anyone it is in the public interest to govern them. So it has long arm, and you don't know who's governed, you don't know who's bound by this law, you don't know what those laws are. And it all comes down to a top-down. And people know me for Bill C-293 and the work I did on Bill C-293 to try to get awareness. And it's top-down again. What we are seeing and witnessing through speech committees is such an unholy terror. And people think that all these are lunch and learns, and I'll take my DEI courses and I'll pay an enormous amount of fees, and then I won't think about them for another year. But the speech committees are how the globalists are coming into our system and cornering us. And in the political realm, I'll use the example of Lisa Robinson, because you think you can vote this out. You think your political power can be used. It cannot. She brings a series of motions. I won't go into the depths of them, but one had to do with change rooms where children were forced to change in the public where adult male and women were, and they couldn't go in their sex segregated spaces. And she brought a change a motion regarding that would enable them to go into sex segregated spaces and not change with the opposite sex. And she was accused of being homophobic for that. And she brought another motion that had to do with flying flags and official flags. And she was accused of being homophobic for that. Now, that was her in-council speech. And by that, I mean that was her political speech. That was a motion that she brought. That was the exercise of her political duty, presumably. And she indicated that she had many, many complaints about these change rooms. Right? So she was the exercising what it was that she was elected to do by her constituents. She had no seconder, so that would have been the political remedy, for those who didn't like this, who thought it was homophobic. That's the political remedy. She had no seconder, and so could not even be voted upon. Why did she have no seconder? Well, because she was pursued immediately by an ethics commissioner, her speech committee. So we have speech committees for lawyers. So are lawyers in the public square speaking freely, right? Are we using our power and our knowledge and our specialized knowledge in the public square? No, we fear our speech committees. Are doctors warning people? No, they don't. They fear their speech committee. And are political candidates able to represent what is the concerns of their constituents if they get elected for that purpose? No, they can't. And then finally, I would say to the left, I call them our love left. It is the power that we are erecting, not that you perceive yourself having a benefit from it, that you should be looking at. It is the unaccountable power that we are erecting through speech committees that is altering permanently our society and our democracy and making us all global citizens. And while it is speech perhaps that some people want culled, or that some people don't like or disagree with or are polarized against, once the power is perfected, it can be a speech that goes against anyone's toes. And this is a power that it was my objective to want to take down in writing World on Mute. And I hope you make it a success. And I gave myself a big task. I'm not saying I did it perfectly, but I wanted at least to move the dial. And there's so many beautiful, wonderful people out there that can take this work and make it important. And I would just ask you to share it with people who have speech committees. Definitely share it with lawyers. Share it with your silent doctors. I show that where we're going is AI healthcare and all the laws that are passing to achieve that have been set out since 2012 through the OECD. And that we are moving to a system where we're governed online, we are governed in the real world through the smart city infrastructure, and the race is that we're governed under our skin, that we're literally moving to the bio-digital convergence. It's a big topic. I've taken on a big topic in this book, and if it's my legacy to assist in this fight, I hope it helps out. And that's it.
It seems for many of us very overwhelming, the speed at which things are changing, and we're struggling to keep up with how do we respond? How do we personally find our courage to activate some kind of response? Now, earlier, Lisa, you and I had a conversation where you were describing how you had been in an accident that left you immobilized for about 10 months. And it was during that time frame that you ended up doing all this research and then starting the journey of writing this book. And it gave me a lot of food for thought, in that for all of us as unique individuals who have our own path to walk, how do we find that path if we want to be participants in the correction that we must involve ourselves in if we want to maintain our autonomy as human beings? And I realized that there's always orchestration of events in our lives that give us the opportunity to explore and to question and to network and to learn new skills. And as we every day embrace that process, it leads us somewhere that actually has a big impact, as your story has been shared with us. I thank both of you for being present tonight, and the amount of emotional resolve and discipline it takes to keep putting your face against the wind and trying to get accurate information and then give it to us in such a way that we, who are not as familiar with the system that you're in, that we can understand, appreciate, and also find our place to be able to join forces with you. It is at this point that I will conclude our discussion tonight. We just aim to expose the critical issues that are now occurring in British Columbia's recent legislation. It's challenging our perspectives, and we're hoping will ignite action to counter the threats to our democratic foundations. I will now hand the microphone over to John Barson, who is the producer for tonight's episode, who will leave you with some practical solutions for our next steps. Be well.
Wow, that was simply amazing. I want to thank all four of our guests tonight. Corinne, what a terrific job! You can sign up. We can have you do this every week if you got the time. Paul, thank you very much for your contribution. Lisa, I can't wait. On a programming note, we are going to have Lisa back next week for the whole evening. So we'll have lots to talk about. So next Thursday at 7 o'clock, you can tune in for a much deeper dive with Lisa on her book, World on Mute. I'm really looking forward to that. In the meantime, what I would like to do is give you some of our tips that we have put together here to help you. Hang on a second. I'm producing at the same time here. Hang on. Let me just fix a couple of things here. Okay. So what I would like to do is just give you some tips to help you promote this conversation. It's a very, very important conversation. As Lisa pointed out, BC is the tip of the spear. This is the battleground. So one, what you can do is you can share the recording of the show as widely as possible in BC and coast to coast and internationally, because as Lisa points out, this is an international program to take control of speech. Two, sign up to receive future notifications of events on hpobc.com. Go to the LPA page, and on the LPA page, which is the live stream page, you can actually sign up for future notifications for programming and updates. Sound bites of this, so we'll be editing this for reposting, so we'll post the whole show in its entirety tomorrow, and then we'll take clips out, really poignant clips out, and spread those around on various social media channels, on X and Rumble and YouTube and Facebook. And please, if you come across those, make sure you give them the thumbs up and share them as widely as possible. Dr. Matthew Cockles, we have a ton of Matthew Cockles sound bites actually on YouTube right now. So on Total Health, you can see them all there. They'll all be listed shortly on the HPOBC website, and we'll post them on Rumble as well under HPOBC's account there. Number 4, share this information with any legal professional you know. We need to have all the lawyers aware of this, and we also need lawyers on the team. So if you're a lawyer with some free time and you love pro bono work, we would love to have a lawyer on our team for advice. That would really help us, because it's a legal morass that we're all living in right now. So a shout out to hopefully a helpful lawyer. Also, and to help production costs, because there's a lot that goes into producing all of this. We're actually asking that if you care, you could send a donation to BC Rising. We'll put a link on our HPO BC website. You can help us out to cover some of the costs for all of this. And lastly, and probably most important, get a copy of Lisa's book, World on Mute. And it's not fiction. It's when you try to wrap your head around all of this. I know when I was introduced to the HPOA, it was only last November, a week before the election. I thought the doctor that was telling me about it was making it up, but no, he's not. This is it. And so we've got to do what we can, because only we have to speak out. All of us have to speak out, and we have to say no. And I'm going to end now, but I want to end with a poignant quote from Suzanne Anton. Suzanne Anton is the retired Attorney General and Minister of Justice for this province. She was that from 2013 to 2017, and I'm going to quote her right now. People did not argue or fight back enough, in my view. There was never enough volume of skepticism to change the mind of the authorities. There was never any science to support all the rules. If you have enough people pushing back, then government can't do it. They can only govern, at the end of the day, with the consent of the people. The members of the public did not push back. The media dropped any semblance of skepticism. The churches did not protest. The people who ran the long-term care homes could have made a judgment call and say it's not worth it to make these seniors be alone, dying, without their grandchildren around to kiss them goodbye. Everyone should have pushed back. During the mandates, if all of the doctors and nurses had said no, actually half of them or less had said no, that would have been the end of it. It's fundamental that citizens should be able to question government decisions in a tribunal setting. End quote. I leave you with that. Thank you very much for your time. I hope you enjoyed this. Again, sign up for the notifications on hpobc.com on the LPA page, and we will see you next Thursday with Lisa Miron and her book, World on Mute, and we'll do a deeper dive. Thank you again. Take care. Be healthy.